There's been a lot of publicity recently about staffing supply chain risk. Wherever contractors are used in the UK, there will usually be a labour supply chain, which could very well include umbrella companies. Umbrella companies should be employing workers, ensuring that all the appropriate employment taxes are deducted. However, compliance is not universal, and some umbrella companies are involved in schemes that could amount to unlawful tax avoidance or tax evasion. In the UK, the government has issued a call for evidence on umbrella company suppliers, and it has committed to bringing umbrella companies under a regulatory regime. We're expecting an update on what those regulations will include this year, and we are hoping they will cover things such as non-payment of workers, skimming of payroll, and non-payment of holiday pay. This update may also include a licensing regime for umbrella companies to help organisations who rely on umbrella companies be more assured of compliance in their supply chains. Any new regulation of umbrella companies is also likely to capture employer of record companies which operate in the UK. We're also likely to see an update on how holiday entitlement is calculated for part-year employees and irregular hours workers. We'll all remember last year when the Supreme Court ruled that employees who work part of the year but who remain employed throughout the year are entitled to a full 5.6 weeks of paid holiday, notwithstanding the fact that they hadn't actually worked the whole year, they'd only worked part of the year. And when calculating holiday entitlement, the Supreme Court ruled that both working weeks and non-working weeks should be taken into account. This means a part-year employee's holiday entitlement accrues not only during the periods they work, but it also accrued during the periods when they did not. The government has since published a consultation on holiday entitlement and setting out its proposals, and the intention looks to be to ensure that holiday entitlement is directly proportionate to the time the worker spends working. This should also confirm the basis upon which holidays should accrue for part-year and agency workers. Finally, across Europe in December last year, we saw the European Parliament reach a deal on the Platform Work Directive. This proposed directive included a legal presumption of employment, seeking to ensure that people working through platforms are granted the legal employment status that corresponds to their actual work arrangements. Staffing companies and online labour and talent platforms who operate in and supply into European markets should be aware of the likelihood of being caught by this new directive and the resulting employment rights claims by their workforce and potential employment tax liability.